Shall I introduce myself? I'm Maria Krasteva. I'm a lawyer. I'm a member of an NGO. I'm independent expert network near us. And in the last 2 years, I have been in the center of this endeavor to develop the communication facilitator figure in Bulgaria. Everything started with two big research events, which our Team Plus Care Foundation did. And these surveys, we surveyed the rights of people with psychosocial and intellectual disabilities in trial and pre-trial proceedings, and in general, their access to justice. So we focused on whether they are given procedural accommodations to facilitate their communication. So in the last 4 years, while we have been surveying this problem, it became crystal clear that all people interviewed shared the same thing. We didn't understand what happened during the trial proceedings. No matter whether they agreed or said yes when they were asked, they told us they didn't have a clue what was going on, in fact. So our conclusions were that such an expert and communication in general is a primary consideration compared to all other rights in terms of access to justice for these people. Later on, I became member of a huge international informal network of professionals across the world. And 2 years ago, at a gathering, it became clear that the issue of communication facilitator is being discussed globally a lot, and it's understood by somebody who would support people to be able to exercise their rights under the Convention for the Rights of People with Disabilities. And this is how we, the professionals from this organization, we started working how this could become a reality in Bulgaria. And there was a training last year where we've managed to train 5 professionals, speech and language therapists, certified speech and language therapists, who would be able to his role professionally. Very briefly about the model, which we discussed together with the colleagues. And we discussed it very in depth in order to make it first in line with the Convention on the Rights of People with Disabilities, and second, to be based on the principles that are not working but are also sustainable. This is how we end up with something that mainly is based on the UK model, or the model that is applied in England and Wales, where it has started some time ago, and we can see sustainability in their models and principle, which with the help of Paula Backen tried to include in our model as well. Briefly, communication facilitators, these are the people who are intermediaries in the communication. They care, their role is to make sure that the communication between the justice system and the participants in the proceedings to be clear. As experts, they are not part of decision making or have anything to do with the legal issues. We're talking about somebody who is entirely focused on making sure that the communication in the process is clearly understood by all participants. Very clearly, very shortly, this process involves assessment, initial assessment of the person, that writing a report by the communication facilitator with recommendations, what communication should, how the communication should be implemented by with the person, and participation of this facilitator if necessary in real time and supporting the communication. Of course, everything is done with the consent of the person. The assessment, the involvement of the communication facilitator, everything is with the consent of the person. The recommendation could be either for the communication facilitators to take part or not. What is envisaged is for the communication facilitators to be appointed by the court authorities. This is the model where each party of the proceedings could request for appointing such a facilitator, but the court and the investigative authorities are those who decide whether to appoint such a person or not. Very briefly now about the model. Maybe you will hear from the communication facilitators themselves. They use various accommodations, including the augmentative communication. They can request procedural accommodations that could be could make the communication easier. Maybe changing the sitting in the room, just where the people sit in the room, how the things are located in the room. As simple as that could be the accommodations. I would like to ask Mitko to show the site, our website, where you can find all the information with the description of the model and the request, also a request form, which may be used by anybody who would like to appoint such a facilitator. Mitko, can you share the screen? Unfortunately, it can be uploaded now. When it is uploaded, I will show it. And last, I would like to add this first group of communication facilitators was specifically trained to work with adults in criminal proceedings. And we believe that this is a good first step to establish this figure and introduce it. And we hope that it won't be the last step. Working in other legal proceedings is also, this is our site, very briefly. Mitko will put the link to it in the chat. What is communication facilitator? You can find the detailed description of this figure and also the list of trained communication facilitators in Bulgaria with a short CV. And at in the end, there is a request form. And in the request form, you will find some guidelines how to identify when such a communication facilitator's involvement is required. You can see the legal basis on which you can request for appointing such a communication facilitator. Now I give the floor to Paula Backen, who should very briefly share as a trainer about the Bulgarian group, how the training went, some personal impressions, and also if you could introduce yourself very briefly, Paula.
Thank you, Maria. I find this very exciting that this project is underway, and I'm really pleased for everybody that this is happening. I've found it a very interesting experience. Let me tell you just briefly about me. I'm based in England, and I've been a communication facilitator for about 13 years, and I've worked with hundreds and hundreds of cases, not just in criminal jurisdiction, but other areas. But today I want to focus on criminal because that's, as Maria said, where we're starting. The training took place from May last year until the end of November, with 2 long weekend sessions together and regular Zoom training sessions between times. I was very clear that because I don't speak Bulgarian and the knowledge of the linguistics and the culture of the area is so important, that I only wanted to train speech and language therapists. I'm a speech and language therapist myself, and there are countries around the world that don't just use speech and language therapists. But as I was an outside non-local speaking person, I thought it was important that we could presume an understanding of communication and the many disorders and disabilities that people have related to their communication. So the training was much quicker because of that assumption. It was clear that there was a group of people with enormous expertise in communication. And my experience in the justice system in England and Wales is that we have to be very clear as communication facilitators that we do not have any legal training, and there are plenty of people in the courtroom and in the police that understand how the legal system works. Our role is very simply to assist everybody to maximize their communication. And we have to come with that expertise. And that is vital, that there is an understanding that we are not the general public who are just providing a support service, that we have a level of expertise. And I can promise you that these 5 people that have done the training now come with a lot of experience and knowledge in the field. However, becoming a communication facilitator means you have to adapt what you know as a therapist to the needs of the legal system. And I think very important here is to recognize the boundaries of the role. The communication facilitator is not the person who drives the defendant to the court. They are not the person who makes sure that they have enough food to eat. They are there not as an advocate for the person, but as an impartial assistant to everybody in the court. So they can advise the judge, they can advise the legal advocates, and they can advise both sides, both prosecution and defense, in how they maximize their communication. And I think it's very important not to see our role as adapting the person with disability to meet the court, but the opposite, the court adapting their ways to maximize communication with the individual. There is clearly a big need. There are many people, as Maria said, who don't understand what is happening in the courtroom and just waits for the verdict. They do not know until the end, and they don't know the words that we take for granted, like verdict and evidence and prosecution. These are meaningless words to them. There are also people who, for psychosocial reasons, will not cope with the concentration that's needed in a courtroom, with the environment, which is so unusual to them, so foreign to them, that their anxiety and their ability to communicate diminishes in that situation. So I in terms of my impressions, I just thought, what a lovely group of people. That was the first thing. And how incredibly hard it was to run training when you had simultaneous translation, and how we had to adapt to local culture. And I want to give you one example of something somebody said on the training, which was, it's not very Bulgarian to fight back and to say, I don't understand, or this isn't right. And it really, the communication facilitator has to be quite assertive in the courtroom environment and has to stand up and say, actually, this isn't working. So it's an interesting role, and it demands not just the knowledge, but also the skills to go with it. The big thing for me is that I work in a legal system that has a jury in the courtroom. And it took me a while to understand how your trials take place and how it works without juries. I know that many countries don't have juries, but it was very new to me. But essentially, I'm just very pleased that it's happening, and I'm amazed at the motivation that everybody has, and also to Maria for making sure this all happened and hold it all together. We benefited from some training from Aneta to help us understand the legal system in Bulgaria, because that's what the speech and language therapists would not know. But I think generally it's gone very well, and I'm looking forward to seeing how the cases come about. And my role is to continue as an advisor, using hopefully some of my experience and knowledge that crosses borders, basically. So thank you for letting me be involved.
Thank you, Paula. It was a great adventure. And thanks to Paula's experience, rich experience, she managed to convey her knowledge to our group. And now I give the floor to some of our communication facilitators already, who perform this function: Rositza, Savova, and Maria Stancheva. They will also share a little bit about the training and how they see this role. So, Rossi, Maria. Hi, everybody. I will start. First of all, I would say that we're very happy to be together. And thank you, Paula, for everything you managed to convey to us. Despite all the difficulties adapting the language and matching the language and everything else, the role of a communication facilitator in Bulgaria is very interesting for Bulgaria. I believe this is a process connected to our professional development of every one of us, and I would like to thank my colleagues that they were so enthusiastically involved in this process, because for me, communication facilitator is something very interesting related to my role of speech and language therapist and my work with people with very severe impairments. For quite some time ago, I knew that just the straightforward therapeutic work is not enough for me. And how we trained people in communication in a very sterile environment that has nothing to do with the real world. So my role as a communication facilitator gave me actually the reply to the question, what happens beyond our strictly therapeutic involvement, and how we can help people live better, have access to everything that have the same access that we take for granted, and provide the same access to these people as well. And we don't take for granted that, and we didn't understand how the communication which we take for granted opens so many doors for us, which is not the case with the people with their communication. So we work with people with very severe communication impairments. And this was very important for my role as a communication facilitator. So everything that happened to us in Bulgaria, thanks to Paula and with the help of Maria and the other colleagues, this helped us reach the point we are now. I really hope from now on, knowing so many things, that we will be able to implement them in the best possible ways, because I'm very well aware that this is something that is going to happen in the future, and this is the bigger part of our job. So we haven't finished our preparation yet. For me, it would be very interesting how we will be able to put in practice all this knowledge and skills which we've managed to acquire and reflect on, and put into this website, and this relatively small group of education facilitators, but this group is not too small for Bulgaria, because we have representatives from different regions of the country, and we are very happy about that. And I would like to congratulate my colleagues for all the effort that they made so that we can meet in person. And now I would like to give the floor to Savova, because she's the person who has been helping me every time when I had a difficulty. And the team is brought together by an idea. Thanks to Paula, we've managed to understand a lot of things about the legal system, and we were able to understand how responsible and how important this function is. So, Rossi, I give the floor now to you. Hello. Good morning, everybody. Good afternoon, everybody. I never know what exactly I should say and how to say it at such events. I was listening very carefully, Paula and Maria, with whom we have been working for 17 years now. And I'm trying to see my start as a professional, first of all, in my work with people with autism and my communication with them, and my start in the role we are talking about today. And I felt very happy that in our group we see Judge Ganivokova, whom I believe we put the start of the role of communication facilitator some 6 or 7 years ago, I believe. Now, this role is a little bit more different. Now it's much clearer to me. Now the tools which we are going to use in order to support and adapt the participation of the person in the court are much better structured, have a structured framework, and I'm much more relaxed with that. The beginning, however, some time ago was difficult, and I was dreaming for a moment when this role in Bulgaria would find its proper place, would be developed. so that the communication facilitator could be seen as an expert who has their useful tools both individual and everybody taking part in a legal proceedings. What we've managed to do actually was to give a start and to regulate in Bulgaria what all of us in the team to share what we agree, what we believe is appropriate for this role in Bulgaria, to agree between of us how to adapt the assessment that we're going to develop, the report that we're going to submit. And I believe that this tool set is the first one I've been held in my hands, who seems very specific, useful, clear, straightforward, that it refers to the individual and their participation in a specific legal proceeding. So it puts clear boundaries for everybody who is going to take part in the proceeding. So this corresponds a lot to my idea how we work and how we see the people we meet every day, because we know about them that they're different, they behave differently in different context, and they would communicate in a different way with different people and in a different context. And we cannot generalize what they're capable of and not capable of, what would they say or not, how they would perform or not. However, this tool allows us to say what we can adapt, what we can recommend, so that we can improve the communication context on this particular issue or this particular case, this particular court case for us. And I believe that this is quite a significant advancement for these expert tools in Bulgaria. Otherwise, as a whole, the training, our meetings with Paula, our meetings with Maria and Danetta were still give me extreme professional pleasure, and I look at them also as an adventure, a great adventure. And this is a dream come true for me professionally. And the whole, the role, the work that I would like to continue. And I'm very clear, of course, that this is just the beginning of it. There are still a lot of things that we need to learn. We need to gain experience. We need advice from Paula, somebody with a wealth of experience. I know that this is something ahead of us, but I feel ready for this adventure. And in fact, this work, to a great extent, corresponds in general with the change in the participation of people with various communication problems in any contexts in Bulgaria. Those, apart from the fact that I would like to continue to be communication facilitator in this role, I'm currently also a different type of intermediary, but again related to adapting the working context in an IT company that they have the same need. They need a communication facilitator that would adapt their working environment in a way so that they can perform it in the best possible way. Thank you. Rossi and Maria, for what you've shared and for your forward thinking of everything we're doing. Now we will hear from our colleagues and partners from different countries. They will tell us a little bit more about how this model is being seen in is implemented in their countries. So first, I give the floor to Paula, who will tell us tell us about the role of the communication facilitator in England and Paula, then Mexico, then New Zealand. Now I give the floor to Paula to tell us about how it works in England and in Wales, and about the importance of this figure of the communication.
Thank you, Maria. Okay, I want to start by first of all talking about the name communication facilitator, because I am so pleased you chose this name. Unfortunately, in England, we chose the name intermediary, and I don't like it. I don't like it for many reasons, mostly because the people we work with can't pronounce it. They can't say intermediary. And also because the general public think an intermediary works in the world of finance. They don't realize it has anything to do with communication. Around the world, the title for this profession has been changed a lot, and you will hear from Mexico and New Zealand about their different titles. But I think Bulgaria has chosen the best because it has defined that it's about communication and it's about facilitation. And I think they are very important. So let me tell you briefly about England and Wales. And I'm being specific here about England and Wales because Ireland and Scotland, that are part of the United Kingdom, don't have the same systems. England and Wales 20 years ago started an intermediary system that was set up by lawyers who were concerned that victims of crimes were not going to court, not giving their evidence to the police, and not becoming witnesses in court. And it took about another 15, 16 years before England and Wales recognised that the defendants also needed some help. What I think is quite important for you to know is that we continue to have enormous inconsistency in our country. It depends which judge you get, which lawyer you get, whether you have a communication facilitator, and whether the communication facilitator is recognized as an expert or considered just a sticking plaster that you put on in the hope that you don't end up with an appeal that the case wasn't managed properly. And 20 years on, I'm sorry to say that in England and Wales, there is a wide variation in how the response is. And maybe that's true of everything in the legal system, I don't know. It seems to me that you're very dependent on whether you have a judge who is understanding and is prepared to spend the time recognizing the expertise of the communication facilitator. And what I hear from Maria and from others in Bulgaria is that you definitely have, as a country, you have a momentum growing of awareness that something must happen. And that's ever so important. The second thing I want to tell you about England and Wales is that it has had a very positive impact on how the lawyers now communicate, whether we're there or not. many lawyers have now learnt from us ways to adapt their way they speak. Not all of them, but particularly younger ones have started to pick up, and in many cases they are using much better, much more specific ways of communicating that are right for the person with the difficulty. Obviously, that's not true of everybody, but there is another side to that, which is that sometimes the courts say, we have experienced lawyers here, we don't need the communication facilitator. And what I really want to reinforce for you in Bulgaria is that every single person with a disability is an individual. And that's why we need to do an assessment, and that's why we need to have an expert who advises the court on how best to communicate with them. I'll tell you on a personal level that if all people with disability were the same and all cases were the same, I wouldn't still be doing this job because I would be bored. Every single one of my cases is unique and individual. And we have a problem if the courts start to say, this person is autistic, so we do X, Y, and Z. And those are the accommodations we need to do. This is why we need expert communication facilitators. And I would implore you to make that really clear to your courts. It's not because we're looking for work. It's because those people are individuals and we need to be specific and we need to use well-trained communication experts to do this job. I have a feeling that at least Sally and probably Diana will agree with me on this. But it is difficult to persuade the courts that there isn't just some generic toolkit that will tell you what to do with somebody with a disability. I think that's really all I want to say, except when you talked about that you're doing criminal jurisdiction adults as a starter. Maria, you said you hope that is the beginning. I have to say we have expanded in recent years. We are doing employment tribunals. We are doing immigration tribunals, coroners' courts, family child custody cases. There are many areas that now want our expertise. So it is an expanding role. And part of your skills are about managing the supply and demand of having the people to do the job and respond. I hope that's helpful.
Thank you, Paula. Will make it difficult if you could share something from your experience, because I know it's so rich.
So I'm going to tell some stories, some real stories, because I think there are things that will worry the legal system, the judiciary, about involving another person in the courtroom. First of all, that we might make things take longer. My example is a man with quite high intellect, but autistic and very restricted by his hypersensitivities, all sorts of things. And they tried 2 years ago to listen to his evidence, and they tried for 4 days. The court spent 4 full days trying to get his evidence. And then somebody said, why don't we ask a communication facilitator what they could do? So I assessed this man and I wrote a report, and they agreed to all the accommodations I suggested, and it took 3 hours to get his evidence. Not 4 days, 3 hours. Secondly, if a man is accused of something and he doesn't understand, he will say not guilty. And he will carry on saying not guilty or no comment all the time. Sometimes I spend an hour in a conference between the lawyer, his lawyer, and the man. And at the end of it, he has understood the evidence that is so high against him that he pleads guilty. My job is not to make him plead guilty, but just think of the time that you save in the court if a communication facilitator just spends time assessing and assisting the person in conference. The other side of the coin is there may be people who say guilty because they're too frightened to come to court. And that with a communication facilitator, justice will be served because they are able to give their evidence, they are able to understand the evidence against them and instruct their lawyer. So in terms of justice, it's very important. There are also people who will say they won't enter the courtroom, and a communication facilitator can find ways to make it possible for them to enter the courtroom and for them to sit in a particular place. I know in Bulgaria people stand. I was amazed. Everybody in England sits down, and I was very surprised to see you all standing. Most of the people I work with would not be able to stand and concentrate for the length of time that the courts require. So there are lots of things that we can do that will make a difference. Simplifying language. You know, only 2 weeks ago, I worked with a lawyer who wanted to use the word duress. I hope the interpreter knows the word. Duress, D-U-R-E-S-S. And when I said to the lawyer, you have to simplify that, he said, we're going to talk about duress in the courtroom. She's going to hear it, so why shouldn't she hear it now? And I said, well, how can you take instruction from her if she doesn't understand the word? He said, well, what word would you use? And I said, well, were you pushed? Were you pressurized? Did you do it because you wanted to? And he went, oh, yes, I'll try that. And then he got an answer. And this is so important to justice. So I promise you, every day that I do this work, I see the difference it makes.
Thank you very much, Paula. It's very important for the to share some practical examples so that people can understand what we are talking about. And we have a little bit delay in our program, but we continue now to Diana, who is our partner from Mexico. And I thank her very much because in this process, she managed to discuss a lot of me for hours on end how to make this figure sustainable, because I believe very surprisingly for me, we found a lot of similarities with Mexico, with both in the legal system and in the mentality of the individuals. So Diana, could you share a little bit how this figure happens in your, what is this figure in your country, and maybe some interesting moments from your experience? Thank you very much, Maria. Thank you very much for the invitation. First of all, I would like to thank you for the efforts that you've made to help all professionals, and to thank Paula for this huge experience she shared with us, and of course to all the professionals who are taking part and who made efforts. And of course, this role needs a lot of strength, not only professionalism. So thank you very much for inviting us to take part and tell you about their experience in Mexico. This meeting made me remember that some years ago in Mexico, we were in the same situation. We had such a meeting with judges and people from the entire justice system to discuss this role. This happened back in 2016, and then our communication facilitators team, more than our communication facilitators took part since then in more than 6,000 cases. First of all, to share about what Paula said. It's a this is a brand new figure in this system, which otherwise is quite flexible, and we took a professional approach, but also we try to open the minds of judges so that they can acknowledge this role and to acknowledge that the people who have problems in communication and intellectual difficulties face a lot of problems in the justice system, in the court. In no way we should limit them, because this doesn't mean exercising justice or reaching justice for them. For Mexico, in Mexico, Israel, even in Kenya, in England, there are situations where, for example, lawyers, but in our case, NGOs were the ones who understood that people with disabilities don't have a real access to justice. So we made a lot of efforts, huge efforts actually. We needed experts who could speak the specific language. But people who need, people in need didn't know what to do. And the only option was to give up and to give up the participation of these people in the court proceedings. In the Mexico case, when we understood that there is such a problem, we started asking ourselves, maybe somebody else has thought about this, and maybe they have recognized this as a problem. And then we started meeting with other programs like this in other countries. We took their experience, people like Paula, people like Sally. They helped us develop our scheme for communication facilitators. We don't have specific legislation for our facilitators, but we base our work on the Convention for people with disabilities, on the rights of people with disabilities. And we base it on the equal rights during the court proceedings. I would like to briefly share with you some ideas about the scheme for facilitators in Mexico and compare it to what Paula said. We use the term facilitators also. Facilitators for justice, actually, is the literal translation of the Spanish word. We work only in Mexico, in the town of Mexico. We're talking about 22 million people, of course, so it's not easy. And we work in criminal justice with criminal judges, and we have received requests from judges in the civil courts. They also look for our help. And unlike UK, in Mexico, our facilitators are part of an organization which is part of the civil society. We take part only in the stage where the judge is present. We believe that also that we need to take part in the initial proceedings as well, even in the police investigation. This doesn't happen in Mexico. I know that in other countries it does happen. It's important to point out that since 2016, in all cases, we remember. What do you want to say? What do you want to tell us that we need to change the procedure, the proceedings? However, over time, the judges managed to understood what is the role of the job of the communication facilitator. And all people who take part in the process, they understood that the participation of people with disabilities is possible. And when they get assistance, their participation is possible. This was very important. The judges whom we met first in 2016, nowadays they use different language. They communicate with people much easier. They ask much more clear questions. For example, even police officers, they ask them, did you see that this person has some problems? What have you done? Actually, the judges ask the police officers, what have you done in order to facilitate this person? So actually, the police officers now have to adapt to the needs of people with disabilities. Here I would like to draw your attention to the fact that sometimes we're perceived like experts who are there in order to help somebody. But we don't help anybody individually. We help the system as a whole make justice adapted to all participants. So actually, we help the judiciary system in general. Of course, it would be the ideal situation would be when we wouldn't be needed. So the people, the magistrates, to make the judicial process so accessible and straightforward and easy for everybody that they wouldn't need communication facilitators, but this is not possible. We don't make some specific diagnosis that help us accommodate something. There are people with the same diagnosis, but they need different support and different accommodations. That is why we need well-trained professionals who can work on a case-by-case basis and adapt everything in a proper way. I don't know whether I could touch on all the issues Maria wanted me to talk about, but it was a pleasure. Thank you very much. Thank you very much, Diana. One last question, because I know that we're similar in this case. From the legal framework point of view, because we in Bulgaria don't have explicit legislation for this figure. It's not an interpreter, it's not an expert witness, it's a specific new expert for which we don't have a specific legislation, but I know that in Mexico you're in a similar situation. However, we believe that there are enough other provisions that could justify the appointment of such expert. Could you tell us how this is organized in your, how this is solved on your side? Our constitution, I believe that in Bulgaria as well and in other countries, we talk about equality and non-discrimination. This is a basic right, fundamental right. And this fundamental right is enough to justify the involvement of facilitators. And also the Convention on the Rights of People with Disabilities. This has it has higher status than our constitution. So everybody in the legal system are obliged, in the justice system, are obliged to implement this convention. Also, the criminal code doesn't provide for communication facilitators, but it provides for equality of all parties to the proceedings, which means that the proceedings should be adapted to the needs of the people who take part in the proceedings. These are the legal provisions that serve as basis for the involvement of communication facilitators. Also, the idea that all parties, lawyers, prosecutors, judges who take part in court proceedings should be should have access to different experts who support them, for example, anthropologists or other experts. So the people who support and help the justice system are various professionals. So our role could be seen as one of these helping people. Thank you, Diana. You will see on the site, on our website, we have given specific legal justification for involving, which you can use to justify the appointment of a communication facilitator. Now we move to our guest. This is a criminal judge in Mexico City, Israel Perez Cuevas. Thank you very much that you've managed to join us, especially bearing in mind the time difference, because we have this is a very, very early in the morning in Mexico. So thank you. Judge Cuevas, if you can tell us a little bit from your kitchen or from somebody who has the central role in proceedings, and how you use a communication facilitator in your work. It would be very useful if you could share about the contribution of these experts and how they help for more efficient communication and in general proceedings. Thank you.
Bien, gracias. Buenos días.
Thank you very much. Good afternoon. Hope that you can hear me well.
Gracias. Agradezco mucho la invitación.
Thank you very much for the invitation to Diana and the organizers. The participation of communication facilitators is very important. In our legislation, we don't have this term, this title, but as we said, our constitution, we're talking mainly about Mexico City, because our experience is from Mexico City. The international acts and the Convention on the Rights of People with Disabilities that has been ratified by Mexico, signed by Mexico. Bulgaria has signed it in 2012. And of course, It refers to the rights of everybody in the legal proceedings. Ratification, the implementation of this convention should be supported, and this is where the communication facilitator comes. The institution managed by Diana is very important because since 2018, we have a guide or guidelines for working with people with disabilities. And we can also call this figure a consultant, an intermediary. Different people call it different names: helper, advisor, or justice intermediary. Sometimes very important is not only the presence of the person, but the fact that they guarantee the equality of people who take part in legal proceedings, because people with disabilities might lack concentration. There are two circumstances that are very important. Sometimes the problem is not only cognitive. Very important are the international requirements for human rights requirements. They're based not only they require not only accompanying of people with disabilities. Sometimes it helps us find out that their families didn't pay proper attention to them from psychological and mental point of view. Very often they lack enough knowledge. They're not capable of taking part. For example, in case of murder or death, some models protect not only the society in general, but also the participants in the legal proceedings. This should also be taken into consideration. If their behavior is more specific, in some cases, specific security measures are required, or the people need to be guarded. Then the justice system will have to take into consideration all these circumstances. And the concept for justice, the concept is that justice should be served no matter what limitations they might have. Or no matter the fact that they might be not capable without support to communicate with us. But we should always provide for their equal rights. If there is no appropriate approach to the person who has difficulties with the communication, nothing would be able to happen. So it's very important for the communication facilitators to help us and to make communication as straightforward as possible so that all participants in the legal proceedings could understand everything at any single point of time. Psychologists, psychiatrists are also involved. Sometimes we need a very specific psychiatric approach in order to keep the communication going. So in a lot of cases, in my experience, with adequate psychiatric approach and supporting and providing the appropriate conditions and accommodations, they can pay more attention to what they're said. They understand much more of what is said, and we break the barrier faced by our communication otherwise. At the end of the day, Mexican legislation defines the different specific functionalities because the facilitation by a psychiatrist could help and make easier. They can decide whether they could stand or they can't stand and should be sitting, for example. They can see what is the psychiatric condition of a certain individual. And this could alter their emotional status. And in some cases, this could trigger aggression as well. So we have to be very careful. We have to use experts. We have to use the rehabilitation specials, the rehabilitation centers. We have to know how much time is necessary, whether these individuals could be present in person in the courtroom. To know how much time they might be able to stay in the courtroom. This is the role of the psychiatrist who helps. May I ask you to share with us a specific case, one specific case where the participation of a communication facilitator helped the process to happen in a more efficient way, and things changed following the involvement of a communication facilitator. Could you please share a different experience and practice?
Bien, sí, de hecho iba hacia ese lugar, porque era la función de cada uno.
Yes, this is what I wanted to do. Communication facilitators used to help me to communicate directly and to tell me whether the person can stay in the courtroom, whether this person understands, how much they understand. Because the court proceedings are held in person. There are some interruptions in the sound. The role of a social worker is very important as well. The help of the families of these people is also important.
Различните видове комуникация. Разбира се, идеята, която трябва да приложим,
Of course, the idea we should apply
средник
when we refer to communication facilitator
е установяването
in this case is to establish
на промените
what are the problems, to identify what are the problems, so that we can adapt the court proceedings to them.
техните специфични нужди,
And their specific needs,
че хората с увреждания
so that in this case, people with disabilities should not adapt to the justice system, but rather the justice system should be adapted to them in order to guarantee their participation and their access to justice. This is one of their rights. Another important issue,
също е свързан с темата.
which is also related to the topic,
Обстоятелствата също предполагат знания,
circumstances also
какво ниво на разбиране
we need to understand, we need to understand what is their level of understanding of the language, whether they understand the evidence that is being introduced to them.
се прилагат специални
We apply special procedures in order to simplify the language.
който да ги придружава.
And in this case, there is a person who accompanies them and helps them. I can give you the following example. If a defendant
Преди се казваше, че имат интелектуални затруднения.
we used to call them people with intellectual difficulties, but they have human rights as well. And for them to understand everything, their intellectual status should be assessed, whether they need more security, whether they need social assistance, whether they need psychological or psychiatric help. They need to be assessed what help they need. And this is related not only with the security in the courtroom, but it relates to the entire adaptation of the procedure so that we can apply the necessary measures that would facilitate their participation in the proceedings. In other words, the model, in many cases, requires for them to be, sometimes it turns out that they have displayed aggression due to the need to defend themselves because they cannot explain. And in these cases, the participation of a facilitator who is a professional to be able to help them in the most adequate way is very important, because it turns out that somebody doesn't understand what's going on during the court proceedings. Everything that happens, all the measures we need to take measures to secure the understanding of this person so that they can understand what they are being prosecuted for. In other words, the model that relies on communication, facilitation in communication, guarantees that the legal system is aware of all the circumstances and can provide the necessary accommodations to all the participants. The assessment should be very thorough and good. And as Diana said, in most cases, we work with only one facilitator. But they should be involved even as early as detention, because this is also part of the rights of these people, because some of them have not only intellectual difficulties, but they might be from an ethnic minority and they don't speak the language. So we need to be aware of absolutely all the circumstances.
Разбирането на това какво се случва на събитията, благодарение на екипа, който е
In many cases, the people understand what's going on only thanks to the people who help with their communication, thanks to the communication facilitators, because some of these people are not even aware whether their behavior was legal or illegal. Sometimes they were not approached in the most appropriate way. Also, the active role of the court is very important, because the court is the court decides whether they would listen to the advice of the experts. We in Mexico are obliged not only to make judgments, legal judgments, legal decisions, but our decisions need to be understandable, need to be understood by the people they affect.
Sencilla para que pueda conocer en concreto y es
Excuse me for the interruption, but there are some interruptions in the sound and it's quite challenging to translate. Thank you very much for everything that you have shared, and for your message that the court should take active part in securing universal environment, and to think as holistic as possible when we talk about observing the rights of people with disabilities, so that they could be effectively involved and exercise their rights. Thank you very much for your participation, and excuse me once again for the interruption. At the end, I will now play the very short video from our colleague from New Zealand, and then I will give the floor for your questions.
Hello, my name is Sally Kedge. I'm very sorry that I can't be with you for your event in real time, but I live in New Zealand and the time difference just prevents that this time. But I wish you all the best for your endeavours in Bulgaria. So my name is Sally and I'm a speech and language therapist in New Zealand, and I work most of the time in the justice system or in related areas. So I'm a communication assistant, which is the title used in New Zealand for intermediaries. I have a position at the University of Auckland as an honorary academic in speech science, and I'm the director of a social enterprise called Talking Trouble. Talking Trouble's work is about trying to enable people to be able to participate in their lives and have a say in anything that's important to them, and make sure they understand what is being talked about or what they need to read or understand. So we are a group of speech and language therapists, and we work all around the country. There's 30 of us now in our organisation. Sometimes we get to do therapeutic speech-language therapy work, which might be what you think of as speech-language therapists doing, but all our work is involved with people who might be having to deal with the courts, the police, justice processes, or with care and protection processes, mental health, or behaviour services. We don't really do normal speech-language therapy as such as we used to. Most of us come from backgrounds in working in health and education. So the work in New Zealand of communication assistance has developed over time. It's had a fairly recent history from about 2012, 2015. Around that time, there were a handful of cases that utilised the existing legislation for criminal cases, and started off having communication assistants appointed for witnesses and defendants in criminal cases. But since that time, the work has expanded a lot, and although we are mainly still doing criminal work on either side of the court, we're also involved in other sorts of cases, family court, and sometimes in tribunals, inquiries, other sorts of processes. Also, in terms of the criminal justice system, we work in related areas, so occasionally in the police investigation stage with complainants, very occasionally with suspects. We also work at the other end of a trial process, perhaps with probation and in the parole service, although not normally therapeutically in probation, but maybe more to help somebody participate and understand a probation assessment that they might have to do pre-sentencing. We also might have a role in family group conferences, which is a very big part of our child protection service and our youth justice service. We work with children, youth and adults, and communication assistants are neutral and impartial officers of the court. We're not there to have a view, we're not there on anyone's side, we're just there about the communication. And most of the time our work is, as much as it can be, about preparing what needs to be in place for somebody to be able to participate and what is then going to happen for them. If we can, we will make sure that everyone is ready, that the context is ready, that everyone has thought about what they need to think about in terms of how they're going to communicate with this individual who needs to participate in whatever it is that's coming up. And then when the actual interaction happens, ideally we will just monitor, because all the work has already been done and everyone has prepared and has what they need to have in place. So in terms of how things are organised in New Zealand, at the moment, all intermediaries are, or communication assistants, as we use that term here, and we're all speech and language therapists. There's a quality framework that the Ministry of Justice has in place that we work from. And when we're not working for the Ministry of Justice and we're not in the actual court or in a court-related process, we still use a very similar framework. We're neutral and impartial, we're not there to have a view, and we follow a similar process where somebody would receive an assessment, we would put in recommendations, those would need to be agreed, and then we would support communication in whatever way we can. However, we're not supporters of the person, we're not there for emotional support as our primary function. Sometimes that's a secondary effect of our input, but we're really there just about the communication and enabling this person to participate in what they need to do. The other day I was near one of our courts and I bumped into one of the judges who I've had multiple cases in front of now, and she made the comment that I don't know how we would do some of the cases without you guys, your work of the team. And I think that now we're in the situation in New Zealand where some of our judges have had a lot of exposure to us, and sometimes they were previously the lawyers who we were working with, and I think some of that has made a big difference, that the lawyers on either side of the criminal court have had a lot to do with us now, and also participated in a lot of training, professional development. We're involved in lots of project work that are taking a much bigger generalist, universal view about trying to ensure there's accessibility for our people who need to come to court, whoever they are. In New Zealand currently we have something called the Te Ao Marama framework, which is Te Ao Marama is a Māori word for coming into the light, and it is a framework that has been introduced to really work on universal access to justice and effective participation for all, and I think our work fits in with that. And that's really brought about a lot of attention to plain language and ensuring people can properly participate. Sometimes our interventions might be very, for us, straightforward things that we would think are common sense. So, for instance, I've been working with somebody who experiences a lot of difficulties with fatigue and sensory overwhelm from light, due to both a physical, I think, and potentially other sensory issues. And so we just change the lighting in the courtroom. It can be as simple as changing the lighting, changing the seating, thinking about breaks, but often it's about the linguistic complexity of the language as well. There's so much I could talk about, but I know that you're having a whole event and you'll be hearing from lots of other people with expertise, and I wish you well for this work and for the work that happens in Bulgaria going forward, that needs to involve everybody, because this is everybody's issue to solve. Thank you.
We finish with Sally from New Zealand. Due to her precise, because she's so precise, she managed to help us develop such a detailed model in Bulgarian that truly represents the principles of the Convention on the Rights of People with Disabilities. We got a very deep insight in the terms and the ideas of the Convention, how to interpret them in Bulgaria. Thank you very much. I'd like to thank very much to all the people present, participants, presenters, and to our interpreters, because I see that there were a lot of challenges involved. But it happens with online to face some technical challenges. I saw one question in the chat. Are you going to read it? Which participants in the legal procedure Paula, I'm sorry, I couldn't. I should. Which participants in the criminal proceedings in England are entitled to such interpreter? The
Yes.
defendant, the
it's
victim,
okay.
the witness.
It's okay. I read it. It's okay. I know there was a question there. Just briefly, originally the intermediary service was just for prosecution witnesses and victims in the criminal sector. It's expanded to defendants in the criminal sector and also to family cases. In the last 2 years, we are now providing services to employment tribunals and immigration tribunals. Interestingly, the government doesn't want to expand our service to suspects and police interviews, although, just to make it more complicated, police interviews with witnesses was the initial reason why the whole thing started 20 years ago. So I just want to make a point here that many of the people we are talking about, this population of people with disabilities, are often victims as well as defendants, and then end up in the family courts too. It's the same person. They may have been attacked, and then they attack someone. They may lose their children because of their difficulties with parenting. It's all, and yet the justice system wants to break it up and say, here is a service and here isn't a service. So it's a good place to start in Bulgaria, to start with criminal adults, but it needs to expand, obviously, if it's to be an equal service. Can I say one other thing while I'm not on mute? I want to say that I think New Zealand has a fantastic service running, and I think it's a model that I wish we had been able to develop ourselves in England. And I think something special is going for Bulgaria. This is a personal opinion. I think if you are a small country with a small population, you are more likely to be successful. And so I really do believe Bulgaria can make this work. I understand the problems in Mexico City. When you're dealing with big populations, you're also dealing with lots of judges. You know, Sally knows all the judges in New Zealand. You know, I don't know hardly any judges after 13 years in England. So I really do believe you will get there in Bulgaria because you've got a smaller population. There you go.
Thank you, Paula. Definitely, we are much closer to New Zealand. As Sally used to say, you're just jogging along on the beach, and next to you is the Prime Minister. Small country, small population. Somebody else would like to pose a question about the specifics of different countries? Rosie? Thank you. I would like to ask the colleagues from Mexico and from New Zealand and from Spain, because Paula used to tell us a lot about the system, told us a lot about the English system. I would like to ask how they regulate the rights of the individual for whom a recommendation is made to use the communication facilitator service. How they regulate their consent or denial, with what document, at what stage, is it in writing or not? At what stage the person should give consent or not to use the communication facilitator's help? Do they take the decision by themselves, or do it with somebody else? I ask this question because we don't have a lot of experience in Bulgaria in this particular case. Thank you very much. This is extremely important. We did discuss it during the training. Shall I ask Paula or maybe Diana? Yeah, but the colleague from other countries as well, because the system is different in all the countries. It would be useful to gather your experience. We have you here now. Paula?
I think you know, I mean, I will say this for everybody here at this conference. I think consent is very, very important. And I've been in other conferences where I have been challenged about as if I am doing something to the person with a disability against their will. I have to say that I have only met 2 people in 13 years who did not want the help. And one of them just didn't like me and wanted a different one. They didn't like my face, I don't know, something about me. I honestly think that people worry about consent, but at the beginning of every assessment, the first time we meet, first of all, the lawyer who refers us to the person or the police officer who refers us needs to ask for their permission for us to do an assessment. And then when we meet them, the first thing we do is check that they are happy for us to do an assessment. And at the end of the assessment, we say, we explain our role quite fully, and we say, would they like us to help them? So there are 3 chances for them to say no. I think that most people with disabilities are just really pleased to finally have somebody who is thinking about their needs and not about the details of the legal case, to be honest. Diana?
Всъщност, in fact, the person can give or not give consent. I can remember only one case where the person didn't agree to get a communication facilitator. We had to inform the judge as well about that. Because always when we introduce ourselves to the court, we have to tell that these people are entitled to agree or disagree with the services of the facilitator. There are no forms for that or documents for that document on paper for that. It hasn't been developed to informed consent. They don't sign informed consent. We haven't formalized this yet, but the judges are the ones who decide that our support is so important for themselves, not only for people with disabilities, but for the judges as well. And of course, the facilitator cannot work unless the person they facilitate doesn't give consent. Of course not. I don't know whether this is an answer to your question, but I just wanted to continue in the same direction, bearing in mind how often the provision of rights to deaf we approach it very formally, but from your experience in England and Mexico, is there something that can guarantee to the court or to the person that could guarantees that the person who declines their consent properly understands what they decline, actually? Do they understand what the communication facilitator's role is when they reject it? Do they know what they reject? Did you get the question?
Yes. Yes. It doesn't happen very often, but I'm thinking of one example where there was a 17-year-old in a multi-defendant case, and all of the other defendants were black and I'm white. And he told his lawyer that he didn't want me because he would look silly with a white middle-aged woman sitting next to him in the dock. Okay. And also I have met others, young people, who, when there are many defendants and they are their friends, they don't want to look stupid. And so that sometimes they refuse. And it is their right. At the end of the day, we have a job to do ensuring they have understood. And an experienced communication facilitator knows how to check that they have understood. So it's part of our job to make sure. We don't just say, did you understand? So that's what we do. Diana, do you want to add anything to that?
I want to make sure how the person understands what a communication facilitator is. The role of the facilitator is to actually make sure of the consent of the person. So I believe we have the answer, but
would it help you if I told you an example, what I would say to the person? Okay. I would say, how do you find going to court? And how do you feel about being in the courtroom? And they would tell me. And I would say, and I have some ideas that might make it easier for you. And I will tell them what those ideas are. And some of them, they may say, no, I don't want to use that. For example, I might say, I find it useful for many people if they hold a little toy in their hands to play with. It helps them with distraction. It helps them to focus. Would you like one of those? And some people say, no, I don't want one. I will feel silly holding one and I don't want one. I may say to somebody else, you know, another idea I have is that you don't go into the courtroom, but you give your evidence virtually online. And we can sit in a different place. And you will only see one person on the screen who is asking you a question, because you have told me you find it difficult when there are lots of people looking at you. And a lady said to me yesterday, I want to try going into court. I said, okay, we will try it. Let's try you going into court. But last time we went to court, you had a panic attack. So we will see how you are on the day, and you decide if you get halfway through your evidence and you want to leave, we will leave together and we will do it virtually. Do you see what I mean? It's not really a decision about whether to have us, because we're not their companion. We're advisors to the court. And so our role is to look at the various accommodations and suggest them. And one of them might be, shall I sit beside you and explain what's going on? And some of them say, I don't want you, I sit beside me, but I don't want you to talk while it's going on. Can you write down what's happening? Or can you tell me afterwards? Do you see? It's a negotiation. It's not an imposition of a communication facilitator on a person. Does that help? I want to say one other thing. I know we're short of time, Maria, but one other thing. We have a role with people who the courts, the psychiatrist has decided are not fit to plead. There are people where with our assistance, they actually can participate. So just to bring those people in as well. Anyway, I'm going to be quiet because we've run out of time.
I would like to add that the role of the communication facilitator the person with disability has been diagnosed by a medical professional, but the communication facilitator needs to approach them in such a way so that this person with disability could use our help. So what are the accommodations we propose should be based on their preferences. They decide, but the last word comes from the judge. So in the center of the system, we should put the person and their needs to make them heard in a system where they haven't been heard before. Thank you very much. Very good ending. Last, I see that we don't have time. I see one last question in the chat. How the communication facilitator can be used in the civil proceedings when somebody needs the protection of the property rights. These are situations beyond the justice system, before a notary public or something. Is that the case? How we can help them? If I don't get it right, maybe Mr. Angelov could clarify it, but if I get it right, yes, you got it right, because a lot of in a lot of cases, in a lot of situations, they end up being victims of fraud, these people, because it's usually about property, quite expensive property. But recently in Bulgaria, there were several such cases. Whether in the other countries, they use communication facilitators in such deals. These are deals in front of notary public. Maybe here, because I know the systems and the function of communication facilitator, I can very quickly say that communication facilitator is a figure that helps the court, the justice system, pre-trial proceedings as well, and not so much in deals in front of notary public, but like in New Zealand and in other countries across the world, as far as I know, more and more these figures start being involved in various processes. Maybe if Paul and Diana know something different. I just want to add, when we have a fraud and when we have to we end up in court when we're talking about fraud anyway. So
Can I just say that it doesn't really matter what the crime is. Once it's at court, a communication facilitator will help. We're really not interested in the topic or the type of crime. And actually, if somebody wants to pay us to assist outside of the court, then we should do that too. That's why we're using people who are experts in communication. It doesn't really matter what the issue is.
in the criminal system, there is no support we industry. The same is the case in Santa Nata Republic. We know of cases where people were convinced to sell their property, or they signed a will and they signed it in front of notary public without at all understanding what was going on. We actually worked in the recent years with the notary public as well, notary public officers as well, as to make them make sure that the people who sign documents in front of them really understand what they're signing for. Actually, communication facilitators can work in civil courts, in family courts, in all sorts of settings wherever facilitating communication is necessary to people. Actually, what you have mentioned, the people are trained to work with adults in criminal proceedings, but I hope that when this role is recognized in Bulgaria, it could be used in other proceedings as well, and including beyond court proceedings as well. You can see the address of our website. You can see the description, the request form. You can send all your questions to our email. And now I have to end our discussion. Thank you very much for your participation. Thank you, Paula. Thank you also for training our group. Thank you, the colleagues from Mexico, the colleague from New Zealand, of course, is not with us in person. She's most probably sleeping now. I see other colleagues, international colleagues, with whom we keep discussing what is the presence of this figure and what its boundaries should be in order to comply with international legislation and the convention. Thank you once again, and have a good, nice evening. And for some of you, have a nice day.